Good afternoon. On behalf of the Georgia Bar and the Atlanta Bar Associations, specifically the dispute resolution sections, I want to welcome you to our program on the rise of mass arbitrations. My name is Joyce Clemmer. I'm the chair-elect of the Georgia Bar ADR section, and I'm also an arbitrator and a mediator with JAMS and a member of the JAMS Atlanta panel. Prior to joining JAMS, I was a litigator for 35 years with a large Atlanta-based law firm, doing litigation, but specializing in intellectual property litigation. But over the past 4 years since I've joined JAMS, I joined JAMS a few years before that, but I've been selected to arbitrate more than 50 cases involving 8 different mass arbitration filings. Some alleged violations of federal law, including the Antitrust Law, Fair Credit Reporting Act, Federal Reserve Regulation E concerning overdraft fees, and others involving state law. For example, the California Unfair Competition Law, the Florida and North Carolina Consumer Protection Laws. And our program is going to address what is mass arbitration? How did we get here? How are the courts dealing with mass arbitration issues? And what are companies doing in response to mass arbitrations? And last and very importantly, how are ADR providers addressing the logistical challenge that mass arbitrations present? Our speakers today have each written very informative articles on mass arbitration and are experienced practitioners who have dealt with such cases. I'll introduce each speaker before their presentation. And if you have questions, please put them in the chat addressed to me, Joyce Clemmer. Our first speaker is Hillary Lucas. She is counsel with the litigation group at Morris, Manning & Martin, focusing primarily on business litigation, appellate work, and alternative dispute resolution. She represents clients in a variety of industries and has specialized expertise in constitutional law, jurisdictional issues, domestic and international arbitration, complex business torts, corporate governance, complex real estate transactions, and intellectual property. Ms. Lucas has filed multiple briefs in the Supreme Court of the United States and other appellate courts on an array of topics, including arbitration topics. Ms. Lucas is a board member of the Atlanta Arbitration Society and previously assisted in launching the Atlanta Center for International Arbitration and Mediation. Ms. Lucas is a proud double dog, she made me say that, and an active member of the UGA Law School Alumni Council. And with that, I give you Hillary, and what is a mass arbitration? And why are mass arbitrations so controversial right now?
Sure. So thanks for that introduction, Joyce, and thank you for having me. To kick things off, I think it's important to know what brought about the advent of mass arbitration. And then secondly, understanding the differences between a mass arbitration versus a class arbitration or a class action in a court. So the practice really emanates out of a case out of the Supreme Court in 2011, AT&T versus Concepcion, that said that the FAA preempted a state law, in that case, California law, that barred enforcement of class arbitration waivers. And that allowed companies to include that waiver in their arbitration provisions, in particular consumer arbitration provisions. And then a couple of years later in Amex, the Supreme Court said that the FAA does not permit courts to invalidate class arbitration waivers, effectively, saying that companies would insist that any dispute be resolved in a bilateral arbitration between the company and the consumer. Now, there have been, as I'm sure perhaps Cliff is going to talk more about later, institutions have started to create rules governing mass arbitrations, which are separate from rules, for instance, governing class arbitrations. And they are continuing to change as I think institutions and practitioners and companies like are having to adapt to these emerging tactics to, for lack of a better word, abuse the arbitration process as a means of extracting a settlement for claims that may or may not have any basis, filed by parties that may or may not actually be in a contractual relationship with the company. Recently, there was a case coming out of the Ninth Circuit that has a good discussion on the difference between, for instance, JAMS allows for the arbitrators to consider consolidation in the event that multiple cases or claims are filed that are related, substantially related. It affords the arbitrator discretion to consolidate. There was a recent challenge to that consolidation process in Jones versus Stars Entertainment, which that decision came out last month from the Ninth Circuit. And, distinguishes a class arbitration in the sense that that arbitration is brought by an individual on behalf of others, whereas a claimant in a consolidated arbitration brings that claim in their individual capacity. And so there are, however many claimants there are that many number of arbitration demands filed with the arbitral institution. And then the question becomes, what comes next? Whether that's consolidation, whether that's appointing a procedural arbitrator at the outset to kind of sort through all that. And I think that it's, especially in the past couple of years, there's been a lot of litigation around the enforceability of these mass arbitration clauses and how the procedures in the arbitral institutions need to work to be fair. And I think we'll get into more details of that a little later, but it's obviously an emerging issue on the, representing companies. I can speak from the corporate side of things. There's been a lot of concern around recent plaintiffs' tactics in connection with mass arbitrations, in a way using the nature of arbitration and its confidential, informal processes to kind of abuse what would otherwise be much more vetted process in the court system. So they can file 10,000 claims, tens of thousands of claims on behalf of purported consumers in the arbitral forum without having to prove up whether or not these claimants are actually in a contractual relationship with the business. And it takes getting through past that initial hurdle of paying arbitral fees, which when each individual arbitration is filed, there are fees associated with each of those arbitrations. And that racks up, just to initiate the case, fees in, sometimes the millions of dollars for the company to have to pay just to get to whether or not the claims are valid and whether or not the claimants are actual customers of the company. And
let me back up or interrupt you for a minute. I think that probably most of the people who are on the program are familiar with mass arbitrations, but for those who aren't, are there basic characteristics of mass arbitrations that are somewhat common through all of them? The law firms representing the parties, etc.
Typically the law firm representing each of the claimants, it's the same law firm representing all of the claimants, and the demand is in most cases identical across all filings, but it is still, each case is individually filed
in the arbitral forum.
in the arbitral forum.
And that generates the fees that you were talking about?
And, JAMS, for instance, has instituted a rule that allows for the appointment of an initial arbitrator with a single filing fee to evaluate the claims. But the tactics, in that STARS case that I was referencing, JAMS proceeded with consolidating the cases, and then, case was filed, or the arbitrations were taking place in California. There's a California law that allows for claimants to disqualify an arbitrator without cause one time, and then any subsequent disqualifications have to be with cause. In that case, even though the case was consolidated, it moved to mediation initially, I believe, but then the claimants moved to compel arbitration. It then came to the appointing of the arbitrator, and with each appointment, some or multiple claimants would disqualify the arbitrator appointed, which they could do without cause. And there was, 10,000 claimants, and that happened over and over again until finally the arbitral forum said, you need to go to a court, and have the court appoint an arbitrator if you don't think that our appointment process is working. The claimants did not take that route, but instead moved to compel arbitration in the district court, and we're effectively trying to allow that process to continue in the arbitral forum to then still kind of force a settlement before getting to the merits of their claims. And it's kind of been a saga of whack-a-mole over the past couple of years, with the various taxes being taken on both sides. You see things about availing themselves of underlying state rules to try and obstruct the process, even when cases are consolidated. Obviously, we see instances where you have like the thousands of claims filed, and there's an initial arbitration fee for each of those cases that, companies, there's the Samsung case, has taken approaches where they've refused to pay the arbitral fee, and the institution has said, okay, we're going to close the case. It's obviously within the institution's discretion. I think in that case, the Samsung refused to pay the fees, and so the claimants were asked that they could cover the fees to proceed with the arbitration, and then any sort of fee shifting could be evaluated on the back end. They did not put up the money, but then moved to court to compel Samsung to pay those fees, and ultimately said that was, the Ninth Circuit said that was within the discretion of the arbitral tribunal, and the courts are not going to compel parties to pay fees, but that has come out both ways.
And it's hard to do a bunch of work or you don't get paid, but like, I'm good with my as
Well, that's happening. Can I interject for a second? No? Okay. That's fair.
All right, I don't know exactly how, I'll defer to Joyce on how we're handling comments and questions.
We're handling questions through the chat rather than people just unmuting themselves. So I would request that everybody keep themselves muted during the presentation, and there will be time for questions. Thank you. I'm sorry, Hillary, that probably threw you off entirely, but What are companies doing? I mean, arbitration is a creature of contract. So, an arbitrator can only do basically what's in the arbitration contract. So if the arbitration agreement provides, there will be, each side will be allowed 2 depositions, or, in some cases, these are the arbitral rules that we're going to use. How, as an arbitrator, excuse me, let me back up. As an arbitrator, I'm constrained by what's in the arbitration agreement as to what I can and can't do, or what the parties agree to, after an arbitration has been filed. So what kinds of things are companies doing to bolster, if you will, their arbitration agreements in an effort to deal with these mass arbitrations?
Yeah, I mean, that's a good question. I think that's something that companies are continuing to explore. There was an initial movement towards including what are referred to as bellwether provisions in arbitration clauses to either designate an arbitral institution who had rules providing for bellwether procedures, which is to take a certain number of these mass filings, have the arbitrator decide those handful of cases, and then from there either to decide to apply that decision to the remaining cases, try to settle the outstanding cases, or proceed to arbitration from there on the remaining cases. So it was an effort to try and stave off this huge upfront administrative filing fee and really get at the merits of the claims before that astronomical filing fee was obligated to the company. But that was recently shot down in the Ninth Circuit, the Heckman v. Live Nation case. At least in the Ninth Circuit, said that in that instance, the arbitral rules were new era ADR, which included some bellwether provisions or bellwether procedures, and the court evaluated those and found that those procedures were unconscionable because they didn't afford the other cases an opportunity to be heard and engage in discovery and that sort of thing. That came out in October of last year. So a lot of companies are now pivoting from the
Other provisions?
bellwether provisions and reevaluating what their options are. JAMS provides has passed mass arbitration rules that the trick there is that the arbitration provision has to designate that the JAMS mass arbitration rules will apply for them to apply, but they are there for the parties to take advantage of at the outset of negotiating an arbitration agreement. And then consolidation, like we've talked about. Fee shifting is largely controlled by the arbitral institution and the underlying state rules. So there's still challenges around figuring out, especially with companies that span every state jurisdiction, how to craft their arbitration clauses to comply with all state laws for all of their customers, and to adequately educate consumers on how the process will work. There's also been another approach has been to allow individuals, consumers, to pursue their claim in small claims court if they want to, before reverting to arbitration. And I think that's still an evolving tactic to try and blend when an arbitration should go to a court for resolution, whether it be on an individual basis or procedural issues implicating the overall arbitration. So those are rapidly emerging questions. I think another aspect that's very top of mind is how to and to what extent businesses can include requirements within the arbitration clause requiring some sort of verification at the outset of an arbitration by the consumer to say, yes, I am a consumer, verifying that you've signed a contract, producing that. I know that some arbitrators have started requiring that, although I don't think it's been institutionalized yet in rules, but in certain cases, the arbitrator said, we need you to come forward with verification that all of these consumers are actual consumers, and have valid contracts or are active consumers. So I think there's some consideration to how and to what extent that can be incorporated into the arbitration clause as well.
I recognize that companies are doing all kinds of things, and the Ninth Circuit, because it is very protective, of consumers. I had a case recently where you were talking about allowing the consumer to bring a case in small claims court. This particular one involved mediation arbitration. If the claim was under X amount of dollars, then it was going to basically binding mediation through a meet-arb clause. So you're right, companies are dealing with this in different kinds of ways. But I think the touchstone, and you have touched on it, is that the arbitration agreement itself has to provide for some of these guardrails, or they won't apply, because the alternative is, I've tried to get parties to agree, okay, will we consolidate these cases for discovery purposes? But absent their agreement, an arbitrator's hands are tied. But thank you very much, Hillary, for the overview. And we are going to turn to Rachel Friedman, who is going to be talking about, and you have her paper, Mass Arbitration Update, The Uncertain Path Ahead. Rachel is a partner with Burr & Forman and is a member of the Financial Services Litigation Practice Group. She defends financial institutions from alleged violations of state and federal consumer protection laws at both the trial and the appellate levels. Rachel represents financial institutions such as banks, fintechs, mortgage lenders, credit card companies, auto finance companies, and debt buyers, collectors in consumer lawsuits filed under various state and federal laws, including the Fair Credit Reporting Act, Fair Debt Collection Practices Act, Telephone Consumer Protection Act, Truth in Lending, and the Real Estate Settlement Procedures Act. Rachel's experience includes defending class actions and compelling claims to arbitration. She's licensed in Alabama, Georgia, Virginia, and Illinois, and routinely handles cases in those jurisdictions. Did you really take all those bar exams?
Thankfully, I was able to wave into some of them.
Okay. And throughout the country for her clients. And prior to joining Burr & Forman, she served as a judicial clerk at the United States District Court for the Northern District of Alabama. Rachel, how did we get here? What are the cases? What are some of the notable examples of mass arbitration cases in recent years and challenges that have been raised?
Yeah, thank you so much, Joyce. So I'm just going to kind of take a deeper dive into some of the cases that Hillary mentioned, and some others. So a lot of these issues, as Hillary mentioned, it's relatively new, so it's spilling over into the courts and fights over who has to pay arbitration fees, who has to decide whether the claimants have to provide additional information showing that they're consumers. Let me just share my screen real quick. Sorry about that. So some common areas of disputes that come about and spill over into the courts, as Hillary mentioned, fees are a big issue. Businesses seek to avoid these exorbitant arbitration fees by looking to the courts, and on the flip side, claimants seek to compel the payment of fees when businesses are trying to avoid paying them. Questions of fairness are big, and the enforceability of the different rules and contracts that address mass arbitrations. That's a question of whether the case should even go to arbitration at all. Next, a big issue is deference in the distribution of authority between a court and an arbitrator, particularly when it comes to procedural issues. You'll see courts often do defer to the arbitration provider because procedure in arbitration is generally a area that courts delegate to the arbitrators and don't want to interfere with. Due diligence of the plaintiffs' firms is a big issue. Businesses claim that a lot of these law firms bringing these claims are not engaging in ethical practices and are not properly vetting these claims. So let's take a deeper dive into some of these cases. As Hillary mentioned, the issue of fee disputes have come out in different ways. On the one hand, we had a case where Uber sued the American Arbitration Association when they were faced with 31,000 individual arbitration demands alleging reverse race discrimination. And when all of those arbitration fees were tallied up, it totaled about a $10 million invoice that they were going to be hit with just to have the arbitrations proceed before even getting to any issue of whether they were liable on the merits. So rather than comply with that payment request, they filed suit against AAA in New York State Court, seeking to enjoin the AAA from enforcing that payment request. But the court denied their request for an injunction, finding that the fees were the direct result of their decision to include a class action waiver in their arbitration agreement. And they ended up having to proceed in arbitration. And the court also found that there was nothing requiring the AAA to tie the amount of the invoice to any kind of actual costs they incurred, because that was one of Uber's arguments, that these fees are wildly disproportionate and basically not necessary to the services that the AAA is providing, but the court rejected that argument as well. And on the flip side was the Walrick versus Samsung case that I believe Hillary touched on, where Samsung just flat out refused to pay its share of the filing fees when it was hit with a mass arbitration brought by about 49,000 consumers under Illinois' biometric data privacy laws. And their filing fees were going to be about 2.5 million. And they just decided not to pay the fees. And as a result, the AAA just closed the arbitration. And after the arbitration had closed, the claimants then sued in federal court in Illinois to compel the arbitration and to ask the court to require Samsung to pay those fees. And the district court did side with the claimants and ordered Samsung to arbitrate, but on appeal, the Seventh Circuit reversed, primarily on the grounds that there was not evidence that the claimants were purchasers such that they were parties to arbitration agreements with Samsung. As anyone knows who's ever filed a motion to compel arbitration, the first thing you have to prove is that you have an arbitration agreement with the other side that you're trying to compel to go to arbitration. And the court found that they had not provided any evidence that they were parties to arbitration agreements with Samsung. But additionally, the court said that even if they had provided such evidence, the court wouldn't have stepped in because it was an issue of the payment of fees, and the consequences for not paying fees was something that was within the purview of the arbitration provider and not something that the court was going to get in the middle of. It's an issue that is normally within the purview of the arbitration provider. And if AAA found that or decided that the consequence for not paying the fees is just to close the mass arbitration, then that was the end of the arbitration, and the court wasn't going to require Samsung to do anything further. And I will note that while Samsung was able to get around paying fees by just refusing to do so, and this worked out well for Samsung, it may not work in a case where the arbitration clause requires the business to pay fees, which a lot of consumer contracts do. They have clauses saying that the business will agree to upfront or to front the fees in an arbitration. But in this case, Samsung's contract did not state that. It said that Samsung would, it said that the issue of fees was going to be governed by the AAA's rules. And so in this case, Samsung was able to get around the payment of fees.
So was the difference between these two cases, did it come down to what the arbitration clause provided, or?
I think in these two cases, a big difference was a couple things. Was who the plaintiff was. So in Uber's case, the business was suing in the middle of an arbitration to try to enjoin AAA from enforcing the arbitration fees, and the court was just not going to do that. They weren't going to get in the middle of an ongoing case, and when fees are something that's decided by the arbitrator, they weren't going to get in the middle of that. But in contrast, in Walrick, when the plaintiffs were the consumers, and the arbitration case had already closed, it shows that the fact that the plaintiffs have to prove that they even have arbitration agreements, even though they had already, filed an arbitration and that had closed. The court said that wasn't sufficient evidence. You can't just go off the fact that you filed an arbitration. We need to see that you actually have an arbitration agreement before we can send it back to arbitration or do anything with it. So I think that those were some of the big differences in those cases. And then, as I mentioned, a lot of cases have dealt with the fairness of the mass arbitration procedure, and several issues that come up when discussing and analyzing fairness of mass arbitrations. As Hillary mentioned, one big thing is the bellwether procedure. If the arbitration agreement or the arbitration provider's clauses or the arbitration provider's rules provide for a bellwether procedure, what does that look like? Is how many cases are going to be included? Is there a time limit on how long that can take? Must the bellwether cases be used as precedent for future cases, or is it just like a guideline? And what happens to the claimant's claims, or the claims of those claimants who are not participating in the bellwether and are sitting on the sidelines while the bellwether proceeding is going on? Is there something that's going to protect their claims from expiring and told statute of limitations on their claims? What does the provisions and the rules say about the right to discovery and the right to appeal? And in general, the courts analyze mutuality, meaning is one side being unfairly advantaged by any particular provision, and or are the provisions kind of evenly applicable to both sides? Let's take a look at some examples. So a couple of cases where arbitration clauses were not enforced because they were held unconscionable are McClellan versus Selco Partnership and Heckman versus Live Nation. In the McClellan case, Verizon tried to update its customer agreement to make it less susceptible to mass arbitrations, but the court struck it down primarily on the grounds that the bellwether provision was unconscionable because it did not provide for tolling of statute of limitations of claims that were not in the bellwether proceedings. There was no time limit to the bellwether proceedings. This was a case where about 2,700 customers had filed, were suing Verizon, and the plaintiff's counsel represented that based on how long it takes arbitrations to proceed, they estimated it would take 156 years for all of the claimant's claims to be heard based on the way that the bellwether provision what the bellwether process was structured under Verizon's agreement, because basically it was a series of bellwether proceedings that went on and on and on, and with no protection for the statute of limitations of the claimants that were not participating in the bellwether. And the court found that it effectively would make most of the claimants' claims time barred, which was not something that could be enforced. And particularly, there was also a clause that shortened the statute of limitations for a lot of claims that claimants were bringing. So combining those two provisions, the court just found that it was not fair and inherently unfair to the consumers. And likewise, in the Heckman versus Live Nation case that Hillary also touched on, the Ninth Circuit held that Live Nation, Ticketmaster's parent company, when they tried to update their arbitration provision to use a new arbitral provider called New Era ADR, the court held that their arbitration procedures were unconscionable because there was no notice of the bellwether proceedings, and just in general, there was no right to discovery. There was only one party had the right to appeal injunctions. So there's just many things that the court found. The court basically said that these procedures are not even worthy of being called arbitration, and was severely critical of the procedures. And so in both of those cases, the motions to compel arbitration were denied on the grounds that the mass arbitration procedures were unconscionable. In contrast,
Let me ask you this, these bellwether provisions, as a litigator, have you run into these bellwether provisions, and how have they worked? I mean, has it been that the bellwether cases are going to be determinative of what happens later to the other claims, or is it just a process by which you're kind of batching claims?
not actually personally dealt with the bellwether proceeding yet, but I think that the way that they ideally are supposed to work, at least in a way that the courts would view as fair, would be more as batching and not necessarily determinative of future proceedings. In fact, courts have held that if that's the case, then there's due process issues, right? If it's a proceeding that the claimant is not even participating in is going to be determinative or binding precedent on their rights, the court has found that that's not necessarily giving them due process. So I think that that's ideally the way it's supposed to work, is more of just sampling the merits of the claim, sampling how an arbitrator would view the claims, and then engaging in settlement after those proceedings have ended, or allowing the other claimants to continue with their claims in arbitration if they choose. But that was just not how either of the provisions in McClelland or Heckman were structured. And I was just going to say that in the Ruiz versus Carmax case and the Brooks versus Warner Media case, those were cases where there were bellwether provisions and they were upheld, primarily because they did toll statute of limitations for claimants that were not participating in the bellwether proceedings. And there were, like in the Brooks case, the bellwether proceedings included many more claimants than in the McClelland case. It was about, I think, 50 or 100 as opposed to just 10 in McClelland at a time. So it would allow the bellwether proceedings to include more people, which the court found was more fair. And I don't think that one actually has resulted in a ruling on the motion to compel arbitration, but in a preliminary ruling, that's what the court said. It rejected some threshold challenges to the proceeding. And
Is
now,
this something that parties could agree to? I mean, to bellwether cases, to a bellwether batch? I mean, I guess the parties could agree to that.
I think they can. I think they can agree. Once they get into arbitration, if it's not already in the arbitration clause, I think they can agree to a bellwether proceeding, assuming that the arbitration provider's rules allow for it. I would think they could. Getting to an example of challenges to procedural rulings in the Mosley versus Wells Fargo case, nearly 4,000 claimants brought claims against Wells Fargo over improper overdraft fees, and Wells Fargo contended that the plaintiff's firm had not properly vetted the claims and that many of the claimants were not even customers of Wells Fargo, such that they shouldn't be entitled to bring the arbitrations in the first place. And they were already in arbitration, and Wells Fargo asked the arbitrator the process arbitrator overseeing the arbitrations to require the claimants to provide some minimal evidence that they were actually customers of Wells Fargo, such that they had arbitration agreements and should be allowed to proceed with their arbitrations. And rather than comply with the arbitrator, and the process arbitrator granted that request, but rather than comply with that order, the plaintiffs sued in federal court while the arbitration was still going on, and the district court compelled arbitration of the claims, granted Wells Fargo's request to compel arbitration of those claims. The Ninth Circuit affirmed it on grounds, a few grounds. One was that the order of the process arbitrator was just a procedural interlocutory order that was not appealable because it was just in the middle of the arbitrations. And also questions of procedure are normally delegated to the arbitrator. And in particular, Wells Fargo's agreement had delegation clauses that delegated the question of arbitrability to the arbitrator. So the court basically said, no, we're not going to interfere with interim procedural rulings. That's something that's within the purview of the arbitration provider and the arbitrator.
I think that probably also highlights the importance of delegation clauses.
Yes, yes. And finally, one other way that businesses have challenged these mass arbitrations is to sue the law firms that are actually bringing these claims, and just flat out alleging in lawsuits that these firms are engaging in ethical violations by recruiting claimants en masse without properly vetting the claims. And I list a few cases where that has been done with varying success. Like for instance, in the Valve versus Zager case, Valve alleged that the law firm bringing the claims did not do any work to evaluate whether the user had a valid dispute and never asked for factual details. But that case ended up being dismissed on personal jurisdiction grounds. In the case of L'Occitane versus Zimmerman Reed, L'Occitane sued a plaintiff's firm that was representing consumers that had allegedly visited L'Occitane's website, and the firm and the claimants in this instance tried to compel arbitration, but their motion was denied on lack of evidence that the claimants had ever visited the defendant's website, such that they were bound, such that they had the right to compel arbitration. And in the Tooby versus Keller Postman case, the plaintiffs alleged that the plaintiff's firm, or the business alleged that the plaintiff's firm failed to vet the claims, asserted claims for tortious interference and declaratory relief. And that case is still ongoing, but just shows the differing tactics you can take, or businesses can take, when they feel that cases are being brought against them, or mass arbitrations in particular are being brought against them that have not been properly vetted. And that it's kind of interesting to see the actual law firm being targeted in these lawsuits. So that's my last slide.
Are most companies, are companies shying away now from arbitration?
I
guess
think
look
most
in your
are.
crystal ball and see where this is going.
Some definitely are. Like I know Amazon is one prime example that I believe has totally removed its arbitration clause from its contract, meaning that they're not going to be in arbitration anymore Most businesses, you know, of course, traditionally prefer to be in arbitrations. That's a pretty bold move of Amazon to totally remove arbitration from their customer agreements. In my experience, businesses are still keeping the arbitration clause. They're just trying to craft provisions that benefit them while not doing it in such an obvious way or one-sided way that the court's going to strike it down as being unconscionable.
Thank you, Rachel.
Yep.
And now we're going to hear from someone who's actually in the trenches. We're going to hear from Cliff Bloomfield. Cliff is a neutral at JAMS, and prior to his career in ADR, he was a litigator at both AmLaw 100 firms and boutique law firms, representing clients in a variety of complex commercial disputes and other matters. Currently, he serves as a JAMS mediator, arbitrator, process administrator, and hearing officer. As a litigator, he represented clients in disputes concerning intellectual property, commercial contracts, securities fraud, antitrust enforcement, labor and employment law. In 2020, he served as a law clerk in both the United States District Court for the Southern District of New York and the United States Bankruptcy Court for the Eastern District of New York. He joined JAMS in 2016. In 2021, Cliff joined the JAMS panel as a neutral and has served as an arbitrator and mediator in hundreds of matters. He's known for his ability to cut through extraneous matters and zero in on the determinative issues. In addition, JAMS, in his employment at JAMS, he serves on the National Arbitration Committee and continues to clerk on complex cases. Most recently, and most relevant to this particular discussion, is that he was instrumental in the development and the implementation of the JAMS mass arbitration protocols and guidelines. So Cliff, in your experience, how do you deal with these monstrosities? I call them monstrosities. I don't mean to be judgmental, but you know, I can imagine that 3,000, 4,000, 5,000, 10,000 cases all hitting someone's desk can be daunting.
It can be. And first of all, I want to say thank you, Joyce, for that introduction and for inviting me to be here. I'm going to share my screen and hopefully it can be seen. I'll answer your question, I promise. But first, I wanted just to go back, starting a little bit earlier than I had anticipated, to the question of how we got here. And as Hillary mentioned, the Concepcion case was quite important. It held that the FAA preempts state laws or judicial rulings, including class action waivers and arbitration agreements. And what was the result of that? I think that's the key. 76% of consumer contracts now have arbitration clauses. Arbitration clauses, which typically have a class action waiver or a class arbitration waiver. And they typically also go further. They say no consolidation. And that creates a problem. Before I recover that, I did want to say that AAA and JAMS require businesses to pay the fees for in consumer and employment cases. So you take that idea and you take the idea that the arbitration waiver or the inability to bring a class arbitration requires individual arbitrations to be brought. And you combine that with the company having to pay the fees, all of a sudden, 1,000 individual arbitrations about the same dispute will create a lot of financial pressure on the company. So that's how we got here.
It's the case that, excuse me, Cliff. So it's the case that no matter, even if the arbitration agreement said, and we'll share costs 50-50, If it's a consumer case, what are JAMS and AAA going to do?
In a consumer case, let's just focus on JAMS because that's what I know most about. In a consumer case, the minimum standards say that we will not administer a arbitration agreement or dispute if the arbitration agreement provides for anything above the consumer having to pay just the filing fee. So JAMS will not administer it. So if you are a company, you either know that going in that you can't have the consumers paying the fees, or you don't, and you're in for a big surprise. And that goes to a key point, and I'm glad that you had me talk about it, which is that arbitration starts with the contract. And so I mentioned just a second ago that a lot of times, in addition to preventing class arbitration, the agreement will say no consolidation. If the agreement didn't say no consolidation, JAMS could, provided the agreement didn't have any other language that prevented this from happening, could consolidate. If 1,000 cases were filed, JAMS could consolidate them. Just to correct something that Hillary said earlier, the arbitrator never decides to consolidate cases, only JAMS does under Rule 6E, I believe it is. And that's what happened in the STARS case. This was a situation where JAMS did not have mass arbitration procedures until May of 2024. When the STARS cases were filed, JAMS made the determination that because there was about 100,000 individual demands filed, and JAMS made the determination that because there was no bar on consolidation, based on the specific language of the STARS arbitration agreement, they could be consolidated. So that STARS decision validated that choice and said that it didn't run into unconscionability issues. And I should have said that the reason why in consumer cases and employment cases that AAA and JAMS require the companies to pay is because there's a lot of case law about unconscionability that basically says that that's the way you should do it. And they're arising in a situation where it's a contract of adhesion, so you don't, it's salutary to take certain measures to protect the consumers.
So some of
That
these
is why-
agreements would be like the click wrap, I agree kind of things, or the clauses that are buried within your agreement with your bank or your credit card company.
It's really any of these situations where you enter into an agreement and you're presented with the terms on a take it or leave it basis. So it's every phone contract you enter into. You can't negotiate with Verizon about whether or not you want the arbitration clause in there. You either sign up for Verizon or you don't. And I bring up Verizon because a bunch of the cases cited deal with Verizon, and it's about 90% of cellular service contracts that require arbitration. So in 2021, I believe AAA had their first iteration of their mass arbitration rules. JAMS took a much slower approach. We reviewed the cases that were coming out, and the obstacle there's a difference in AAA's approach to mass arbitration and JAMS in that if you file AAA's procedures apply to all mass arbitrations, whether or not the contract specifically references AAA's rules about mass arbitration. We didn't think we could do it that way, or at least JAMS didn't, I shouldn't say we. And so we require that the JAMS procedures be specifically referenced in the parties' agreement. We have a threshold requirement of 75 arbitrations where they're related and they have the same counsel or coordinated counsel. That's our definition of a mass arbitration. A lot of the other providers say 25, and frankly, because it's a matter of contract, if the parties say 25 in the agreement that specifies the mass, that the JAMS procedures, then we'll do 25. All right. So another difference between, well, I'll take a step back. As you know, Joyce, because you mentioned it, there are lots of mass arbitrations that have proceeded where the cases are each individually filed. And you mentioned one that I've been an arbitrator on in several cases. I keep getting new ones, in fact, and it's interesting in that context to get a new case where you've already ruled in a certain way. So you can administer separate cases, but it is problematic for a lot of reasons, including that I don't know, the first case I had involving one of these mass arbitrations as an arbitrator was in 2021, and I'm still doing different cases in 2025. Those claimants are not getting to a hearing and an award in a efficient or rapid way at all, and that's antithetical to the arbitration process. So we will honor the party's contract always, and so if individual arbitrations are required, that's what JAMS will do. But if the mass arbitration procedures are specified, then we have a procedure where the sort of preliminary administrative issues typically done by the National Arbitration Committee or JAMS itself, they're synonyms, those two terms, will be decided by what's called a process administrator. We don't have a process arbitrator like AAA does. And there are a couple of reasons for that. One is simply that the process administrator isn't doing the job that an arbitrator typically does. And even if you call one a merits arbitrator and the other a process arbitrator, the role is different enough that I think it's useful to have a different term. And also, especially in California, the parties can continually object to a arbitrator until you go to court under the FAA, and you can have the court appoint the arbitrator. But we didn't want that gumming up the works in the beginning of the process. So we have someone called a process administrator who's not governed by the same rules as arbitrator would, and in fact serves as an adjunct of JAMS. You get in, you immediately hold a preliminary conference to identify issues and set up a plan for resolving the issues. And then from there, it's step-by-step problem solving. You know, what do we have to tee up? What do we have to decide, with the goal of getting the cases to the arbitrators who are going to be deciding it as quickly as possible. Now, I serve as a process administrator. I have cases pending before me, so it's a little bit difficult for me to talk about the specifics or the challenges that are going on, but let me just, in a very general way, cover some of the subject matter that a process administrator is allowed to consider pursuant to the JAMS mass arbitration procedures. So whether the filing requirements on these procedures have been met, and Rachel already spoke about the Mosley case, and she had a better site. She had the Ninth Circuit affirming. The parties can raise threshold jurisdictional and arbitrability disputes. Now, that doesn't mean necessarily that the process administrator can decide arbitrability disputes, but at the very least, they can be identified, and they can be identified to determine whether this is subject matter ultimately for the court or for an arbitrator, depending on the language of the parties contract, whether conditions precedent to the arbitration have been met, whether to batch, consolidate, or otherwise group demands in the mass arbitration. Now, we were aware of the McClellan decision, and so our preamble to the mass arbitration procedures makes mention of the fact that we don't use test cases. That isn't the idea of what we're doing here. It's simply to group them in such a way that they can be dealt with in a efficient way, so that justice can be served as quickly as possible. I'm a big fan. When it was drafted, we have the language, I believe, group, batch, or consolidate. I'm a big fan of the notion of a consolidation of claims. So similar cases can be grouped together in some way, which allows for streamlining. You could have consolidation, for example, just for discovery purposes. You could have consolidated hearings, avoids duplication of efforts. Joyce, you mentioned something about parties seeking, or you suggesting that there'd be some sort of consolidated effort. I'm assuming that those are cases all before you?
Yes, well, one set of cases is over with, but what I did in one case, for example, with the consent of both claimants and respondent, was have them agree, or they agreed to, consolidated discovery. You know, for example, if you had 3,000 cases and one equivalent of a 30B6 witness from the respondent corporation, is that person then going to be deposed 3,000 times? Or can we agree that
Yes,
he or she will be deposed a limited number of times, and each of the claimants can be individually, so consolidation, for example, for purposes of discovery, but with permission of the respondent and claimant.
right. So I mentioned earlier that under the JAMS rules that would apply to, let's say, any arbitration, any commercial arbitration, it is JAMS that's making the decisions about consolidation. It's typically not the arbitrator. And so consistent with that, we would have a process administrator making these decisions about consolidation. In the Heckman case, the real issue there was that a lot of the rulings up front it was sort of an MDL style, where you had a first group, and those rulings would have precedential effect on non-present claimants. And the Heckman court said that this is inconsistent with the language in Concepcion that said that the reason why California can't preclude class action waivers is that you'd essentially be asking the parties to litigate in such a way that is inconsistent with the arbitration under the FAA, because the FAA is supposed to be fast, efficient, and you can't, the Rule 23 rubric, where you have the procedural safeguards in place to protect absent class members, and so that you can have representative decisions, it can't be instituted in arbitration. Now, I disagree with that, but the point of mentioning it here is that Heckman said that this procedure, where a batch would be determined and have a precedential effect on the remaining claimants, they said violated that principle, and therefore the FAA couldn't preclude it. But with the JAM system, or my favoring consolidation of claims, this quote, I believe it comes from Wright and Miller, and it's describing what consolidation means under the federal rules of civil procedure. And you could see that this type of consolidation does not merge the suits into a single action or cause the parties to one action to be parties to another. So the idea would be to keep these cases separate, and to proceed with the same procedural safeguards that you'd have in any arbitration where you're trying to do fairness with efficiency, and to group it in some way, but not to do what was prohibited in Heckman. I should also mention the JAMS fee model. I've spoken about the JAMS procedures about this is my third time, and each time I forgot to mention the fee structure, so I'm glad we're here and I have it here. So instead of being on the hook for millions of dollars in filing fees, under the new model that applies only in mass arbitration procedures, which again only apply if the parties put it into the agreement, there's an initial fee and the costs of the process administrator, whatever their billing rate is, that they charge that. But once it goes into the hands of the merits arbitrators or the arbitrators, only one fee is charged per arbitrator. So if you have 100,000 cases and two arbitrators are assigned each 50,000 cases, for this hypothetical, that's only two fees. That varies greatly from the AAA model, where there are basically the fee is X for first 500 and so on and so forth. And then you also pay the normal fees of the arbitrator.
Cliff, I think we're just about out of time here.
That's perfect.
Any closing thoughts?
I do not think so, but if there are any questions, I'd be happy to answer.
All right. Well, we are out of time. We're actually over time. So thank you all for staying with us. Sean, are you still on? Did you want to make a quick announcement about the May program or no? Maybe he's not still on.
Yeah, I'm Sarah. No, we can close. It's okay.
Okay. I want to thank Hillary, Rachel, and Cliff for being on this program today. As you've all heard, there's a lot to unpack when it comes to mass arbitrations. I hope you found this helpful, and we look forward to seeing you again. Thank you.
Ladies and gentlemen, this does conclude today's meeting. Thanks for joining and have a great afternoon.